you start, first of all, there's a couple of things that you can gather up and respond however you'd like. First of all, I think I read something. We're all buried in stuff here, and I'm speed reading it as quickly as I can and listening at the same time. This was not remanded back to the Planning Commission. Staff felt that that was a decision of ours, if that's number one. Number two, we've got a lot of documents here, and I don't think anybody, staff or petitioners or the people that are opposing this, are into the business of fabricating letterhead and fabricating emails and lying to us. With that said, the original zoning administrator, Donna Thompson's, to appeal her determination, the letter was sent, there was a response, and basically Ms. Thompson said that she felt they were challenging the comp plan and not the zoning code, which is her purview, the zoning code. It was resubmitted differently a day or so ago, and that's what's in process now. So this is so complicated. This is, I believe, a case where everybody is stating the facts as they know them to be. And I believe, unless it doesn't happen, the resubmitted version is going to the BZA, and if that appeal is upheld, then we'll leave it to the Office of the County Attorney to say where we are here. The last thing that I'm bundling up is there's email transmissions back and forth, some of them very recently, like 2 weeks ago, where our staff seems to be saying we're in the process in the first UDC amendment cycle at looking at changing one word from unplatted to never platted. And if that's the case, that impacts this. But again, it's been in process a long time. We haven't even decided exactly when, post-glitch amendment cycle, the first UDC amendment cycle is going to occur, and staff is just getting their arms around this. So I tried to speak slowly, and hopefully that'll help you shed light and save you from dozens of other questions.
Nice answer, Matt. Good afternoon, Chair, Commission. For the record, Matt Osterhoudt, Director of the County's Planning Development Services Department. I will be signing my speaker's card momentarily. So let me unpack what you just referenced, Commissioner, one by one, go through those items. We were remanding back to the Planning Commission, and that determination was made through our department because of the less intensity of the development. That the Planning Commission was receiving less units out there, and that this particular item they'd already reviewed as part of the actual technical merits. So we did believe that this should be a matter for the board, not remanding back to the Planning Commission, and we could not find anything in the UDC that prevented it. When we talk about the last point that you brought up, and then I'll go back to the zoning interpretation, I think it's easier to follow that path. Regarding the UDC amendment cycle, the UDC was adopted late last year and began implementation January 1st. For those members of the public who may not be aware, we combined our zoning regulations and our land development regulations into one document. So the processes merged, which I'll come back to in a second. As part of that, we did a glitch bill, because we had a couple errors in there. We were only human when we did that. We did fix those pieces earlier in the year, and we're about to open up the second cycle. That would occur this summer and moving into the fall. That matter will come before the board later this year. It's my understanding the topic that you brought up about unplatted versus never platted would be something that would be considered in that second cycle that hasn't happened yet. So let's move on to the final couple bullets that you mentioned regarding the process for a written interpretation. And I think if you'll indulge me, Chair, for just a moment, I've got a couple sheets here for unified development that I think would be worthwhile walking through how those interpretations work. This is something that is still relatively new, and I do want to highlight exactly what Commissioner Mayo referenced earlier, that this is not an easy process for anybody, including staff at times, no doubt the board, no doubt the citizens that are in this room. So the Unified Development Code does have several sections on procedure. This is the first section, 124.45, that gives staff the ability to do written interpretations of the Unified Development Code. I do want to note that in the past, prior to the Unified Development Code, staff was only authorized to issue written interpretations relating to zoning. Provisions relating to other things, environment, utilities, stormwater, and even 2050, those didn't have an appeal mechanism. So when we combined it into the Unified Development Code, we now created a more universal framework for issuing written interpretations and then appealing of those. Now, if you see here, you always have to start with an applicability statement, so I'm going to zoom in a little bit so everybody can see, and I'll put a extra line of text here. One little thing out. There we go, I think that's about right. So in that first line, I'm just going to go ahead and read it into the record. The administrator is authorized to issue written interpretations of this UDC, including but not limited to the following: interpretations of the text of the UDC, interpretations of district boundaries, interpretations of stipulations on rezonings or special exceptions. Those would be already approved rezones and special exceptions. Interpretations as to whether an unspecified use falls within a use classification or use group allowed in a district, and interpretation as to whether a proposed use of equal or lesser conformity. So those are the parameters that the board has granted the ability for the administrator to issue interpretations. Not on this list is how those provisions specifically affect a particular application that is already in for review or coming before this body for determination. That is a separate process, like the county attorney referenced earlier, and that's the due process that we're in right now. It's the planning commission, it's the neighborhood workshop, and ultimately this county commission, several opportunities for the public to have input as part of that due process. Now, so once we get beyond the first piece of applicability, that has to be an interpretation of the text, not relevant to a particular application, but relevant to the text, we move to the next section. That talks about once you've actually granted the written interpretation, you talk about the administrative appeal process. And so this lays out how you can do an appeal. And the very first test that has to be met within that section is that you have to be an aggrieved party. And I think one of the things that's complicated this situation, going back to what Commissioner Mayo referenced, is what was being asked applied to several sections of the Unified Development Code, as well as the comprehensive plan. And so, to make this a little bit more confusing, but hopefully make it clear for today, there is no appeal process that I'm aware of for things relating directly to the comprehensive plan. Those would be conversations that would happen here during this public hearing to make sure that a reason is consistent with the comprehensive plan. You can see here Article 7, the interpretation that was made by staff related directly to Article 7. That is something that goes to the Board of Zoning Appeals when you again are an aggrieved party. A lot of the 2050 provisions that we're talking about today are located in the comprehensive plan. No appeal process, but there are some sections in Article 14 of the Unified Development Code, and that is right here. You can see that those things would come before the board. These are other sections like environment, utilities, stormwater, transportation, those things come to the board. But ultimately, they have to be an aggrieved party. And at this time, I don't believe we have an aggrieved party. No development board decisions have been met. We have not approved something, we've not denied something. In fact, that due process is playing out right here before us. So once you go to an administrative appeal section, it moves you to the next section right here, which is 124.47. That was the section that was referenced earlier today in the hearing, so let me move to that section. So here we are again in applicability. It's always important that you do an applicability statement where this applies. And you can see that this applies to owners or applicants, that they go to the Board of Zoning Appeals for a board, and then again have very similar language to the Board of Zoning Appeals for these particular articles. The one our staff made a written interpretation on was Article 7, versus a lot of 2050 provisions that are in Article 14 of the comprehensive plan. And then ultimately you get to the language at the bottom, which was referenced earlier about the staying of the proceeding. But what we looked at in the Unified Development Code is that prior section that I talked about. But you have to meet those first tests. It has to be a specific, applicable, written interpretation of just the text. And then once you disagree with that, you have to be an aggrieved party. And what this is intended to do speaks to, let's say somebody is moving through a site development process, and they are having an issue, doesn't matter if it's stormwater, transportation, or environment, and that decision is going to be weighed administratively. This is a mechanism for somebody in that process to say, rather than being denied, I would like to appeal that decision to the board and then be able to come back to the administrative process with that decision. So going back to where I began, I think this is a very complicated matter. Hopefully I brought some clarity to it, looking at the actual code language that's here. And then moving maybe over to the county attorney as well to reiterate that there are two separate due processes. One being what we talked about here, and whether or not somebody's applied for written interpretation, which is a separate due process than what we're in right now. I'm glad to answer any questions and unpack that a little bit more if I need to. It is not the easiest thing for anybody in this room to be able to follow.
I got it. I mean, we have a difference of opinion between people that have testified. Our county attorney, our folks are saying they're pulling out a position that says it shall be stayed, but